Good afternoon, Inspector. You are live on YouTube.
Good afternoon. Can everyone hear me? Is everyone present?
Yes, we can.
Yes. So the inquiry is resumed, and any matters anyone wants to raise that have come about over lunch? No. In that case, I'll if Mr. White and Ms. Goodyear can continue, then please. Thank you. So I'll hand over to Mr. White to ask the questions.
Thank you, sir. Ms. Goodyear, can we then, as previewed before lunch, could we please take up SP2?
Yep.
And it's on page 22 of the local plan.
I'm there already.
Wonderful. Right. Let's just have a look. So can we agree that SP2, actually, before we do, let's just look at, please, page 21.
Mm-hmm.
Well, just to set the context, we note at 2.76, let's just look at the context, that at the time when the plan was emerging, there had been a shortfall between 2011 to 2018 of 2,462 dwellings. Do you see that in 2.76?
Sorry, yeah, I thought you said page 21.
Yeah, I did. I had a change of mind.
Gone back further.
I had gone back further. It's such a good point that I thought I must touch on it. No, just 276. I'm probably, after you break a rib, they say don't laugh. Probably with you in your state of your cough, I mustn't try and make you laugh either, because that wouldn't have good consequences. But 276, please, Miss Goodyear. That's on the presumption I can, which I don't know if I can. 276. We note that the council identified a shortfall of 2,462 dwellings, did they not?
Yes.
And what they say at 277 is the local plan provides the opportunity to address this position and determine a robust and sustainable approach to rectify the shortfall.
Yes.
And of course, like as we discussed before lunch, most plans start off with a degree of optimism. And then if we move on to 2.83, we see dealing with any future housing shortfall. They say the scale of allocations proposed in this plan should ensure that there will be no significant housing shortfall in the future.
Yes.
I mean, obviously, time has shown that optimism was not correct.
I think in the interim, Stodmarsh, the issues at Stodmarsh came up, so that couldn't have been predicted, obviously, when they wrote this.
No, it couldn't have been. But the fact is, whatever the circumstances, I mean, as we've discussed, the MPPF doesn't allow you to, so to speak, to have mitigating circumstances. Remembering the early glorious years of Mr. Howell Williams' practice and mine, when we used to give pleas of mitigation, obviously the MPPF does not recognise mitigation for why you've got a shortfall. It's just interested in the shortfall, isn't it?
Yes, but as I said, I was just qualifying this point.
Okay, then at 283 we see, however, in the event of a housing shortfall being identified in the future, the following considerations will be applied. And we see various comment, and we see that what effectively is said is this is reflected in at 284. Although this local plan does not propose separate policy-based housing targets for different parts of the borough, unlike in some previous plans, it is clear that there are very different policy priorities for Ashford and its periphery, which focuses on managing and sustaining growth, in comparison to the rural areas, which focuses on managing small-scale change in a way that protects the borough's attractive rural character.
Yes.
This is reflecting the overall scale of new developments proposed for each planning area. These respective priorities should be used as a guide by the developer and decision maker as to the way in which the local plan approach should be applied, namely that should not be significant substitutions of housing numbers away from Ashford and its periphery to the rural parts of the borough. Mm-hmm. Now, I just want your planning judgment. Do you take what is proposed by the development to be a significant substitution of a housing number away from Ashford?
I think it is significant. It's 145 dwellings that will be taken away from Ashford. And I think I said that in chief.
Well, but can I say whether I'm going to put to you that to say 145 dwellings is significant is a matter where the inspector might have sympathy, he might not. But of course, away from Ashford, the assumption, of course, is away from Ashford. I mean, you have no evidence, frankly, that this proposal is taking housing numbers away from Ashford, because we're in a world that is written in the context of effectively the strategy which we know is not delivering, isn't it? Ashford is the failure in the system is an Ashford, isn't it?
At the moment, Ashford is unable to deliver due to, well, to some respects due to Stodmarsh, although actually we have seen recent approvals come through with their own mitigation. So it's a temporary circumstance. It's not that Ashford can't deliver.
No, but
and it's not that Ashford is no longer the most appropriate place to deliver.
I didn't put either of those two propositions with you. The reason why, let's completely get to the nub of the point. The reason why there is a shortfall is the Ashford allocations have not delivered for whatever reason to the extent that was predicted in 2019.
But yes, and for the reasons that I set out.
And yes, but that is where, so in a sense, a strategy which focuses on Ashford, which is then frustrated because of Stodmarsh, is a strategy which is obviously influenced by the circumstances in February 2022, isn't it?
Yeah, but I think the strategy is also one of two parts. And yes, it's focused on Ashford, but it's also about looking at the rural area and making sure that development is appropriate to the sensitive location. But
look at also 286 is the nub of it, and this is frankly I'm going to put to you what you haven't grasped, because it addresses exactly the situation we face here. Do you see the sentence beginning? However, if a borough housing shortfall in supply occurs as a result of significant non-delivery within Ashford, that's the situation which we're in now, isn't it?
Yes.
And its periphery, the variances in policy emphasis between the two planning areas are Ashford and its periphery and the rural area, isn't it? Will need to be weighed accordingly alongside the need to improve housing land supply and meet housing needs. Now, that I'm putting to you that's completely grasped the nettle that we face, that the housing supply is that scenario, and the policy emphasis, SB2, must be read in this situation where the need will be weighed accordingly alongside the need to improve housing land supply and meet housing needs. That's what the council said in their local plan, isn't it?
Will need to be weighed accordingly, yes. I think it's a judgment.
It is a judgment, but it's frighteningly prescient of February 2022, isn't it? That the author, there's someone in the policy team who should be called Nostradamus, because they've actually forecast exactly the situation we face, frankly, where when you have non-delivery within Ashford, you need to effectively, the variances in policy emphasis between the two planning areas will need to be weighed accordingly.
Weighed accordingly, yeah, I think that's right. And I think you need to take the circumstances of that into account. And as I said, it's a temporary problem at Ashford. So I think that needs to be taken into account. And I think that's what they mean by weighed. It's taking on that judgment. It's making that judgment.
Ms. Goodyear, with the greatest respect, you do nothing of the sort. What you say, the strategy set out in SB2 remains valid. You dealt with this in examination chief. You say to the inspector that irrespective of what's happening on the ground now, SB2 must be given full weight. So you're not weighing accordingly to the circumstances of non-delivery within Ashford. You're just completely staying on the same road as if there was no shortfall, aren't you?
I think I am in terms of the way I'm giving it weight.
But I'm saying,
I think we've already discussed that.
Well, whether we've discussed it, what we haven't discussed is 286, which obviously by its inclusion in the local plan was meant to mean something. And by clear implication, if you have significant non-delivery, you do three things. You consider whether there should be a variance in policy emphasis between the two planning areas, correct?
Sorry.
You've got to do one of three things if there is significant non-delivery. The first one is you've got to consider variances in policy emphasis between the two planning areas.
I mean, this is supporting text, yeah?
Yeah, everyone knows what the status of this is. Can I put my question again, please?
Yes.
You've got to do one of three things. You've got to consider the variances in policy emphasis between the two planning areas, haven't you?
Yes.
Secondly, you've got to consider the need to improve housing land supply.
Yes, and weigh them accordingly.
And thirdly, you've got to meet housing needs.
Yes. That's what that
And
says.
have you considered those three factors in your evidence to this inquiry?
Oh, I think I have.
Yeah, and in reaching full weight to SB2, you've considered those three factors and still concluded that full weight to SB2.
Yes.
Yeah, well, I'm going to put to you again that in the light of that exercise, what is 286 is completely irrelevant to you haven't done anything of what effectively is required if you come to identical position as if that wasn't engaged effectively.
Sorry, is that a question?
Yes, it is a question. You know it's a question.
Sorry, I just didn't think it sounded like
All
one.
right, well, if you want to...
But
You know it's a question, Miss Goodyear. Please answer it. I don't want to test of when things are difficult, you don't answer it. Do you want me to repeat it?
yes, sorry.
Yes, you have accepted. You need to consider those three factors, and the outcome in considering these three factors is identical whether 286 is engaged or not engaged in your planning judgment, isn't it?
In my judgment.
And then we see 287, significant numbers across the borough will be monitored annually. If a significant housing shortfall against the local plan target becomes apparent, and housing trends suggest that this will not be a short-term issue, the council will seek to implement the review of the local plan earlier than expected, currently expected to be adopted in 2025, as a means of ensuring that a plan-led solution can be delivered to rectify the situation. Do you see that?
Yes.
Do you accept that the 664 in the context of 287 amounts to a significant housing shortfall or not?
It's a shortfall. I think the plans also, it also says in 287 a short-term issue.
No, can I go back to the question? Miss Goodyear, we can make it, please try and concentrate on the question. I've learned from Mr. Howard Williams to say, please focus on the question. I asked you one very simple point. Is it in your judgment a significant housing shortfall, on which you replied, it's a shortfall? You know what the question was. Is it a significant housing shortfall of 664 units or not?
Yes, I'd say it is.
Thank you. Now, let's then go on to SP2. So, first of all, the net housing requirement is 13,108 net additional dwellings applies for the borough between 2018 and 2030.
Yes.
Yeah, that figure is now out of date, isn't it? Because the requirement that you've agreed with Mr. Taylor is effectively 7,100 just for 5 years.
Which takes account of the shortfall, which I think is addressed below.
Yes.
Yes.
That's not the point. The 13,118 net additional dwellings in SP2 as of February 2019 do not assume a shortfall from 2019 to 2022.
Okay, sorry, yes.
Yeah, so that figure, the target that faces Ashford supersedes the target set out in SP2, doesn't it?
In terms of the housing land supply calculation, yes.
And consequently, that paragraph of SB2 is out of date. It's superseded by the agreed requirement that now exists between you and Mr. Taylor.
I think, yeah, you can look at it like that, I suppose.
Well, don't make it sound like in some way this is a unique quirk of my approach. We can go to the requirement if necessary, but the requirement is significantly higher because there's a shortfall of 2,300 units agreed.
Okay.
Then we go on, the housing target will be met for a combination of committed schemes, site allocations, and suitable windfall proposals.
Yes.
So in meeting that target, it's implicit in SB2 that windfall proposals will be utilised as a component of meeting the overall strategic requirement.
Yes.
Yeah. So on the face of it, then, I simply don't understand the contention. Put aside the geography, but we can agree that windfall proposals, such as appeal decisions, are within the terms of SB2.
They are, but you have to read through the whole of SB2 and the fifth paragraph, which says where it is consistent with the spatial strategy outlined above and is consistent with other policies in the local plan in order to ensure that sustainable development is delivered.
Yeah, we'll come. Don't worry, we'll come on to those. But I'll go back to my question. Suitable windfall proposals are inherent and fundamental to how the council sees meeting its strategic housing requirement, isn't it?
They're one of three parts subject to the tests set out in the policy.
Thank you so much. Then, the majority of new housing development will be at Ashford.
Yes.
51% of new housing in Ashford would comply with that, wouldn't it?
Well, that would be, yeah, that would be over half. So
can I have a yes, please, or no?
I think, well, it would be a majority, as it would be 51%.
Thank you. And then, and as the most sustainable location. But we can agree that if the strategy is complied with in relation to third paragraph, if you're above, if 51% is being met in Ashford and its periphery, that is the ambit of what SP2, the third paragraph, seeks, isn't it?
Yeah, it's seeking the majority of housing to be at Ashford.
Well, in the light of that, I mean, it's quite, I mean, this whole development, focused, various terms have been bandied around by you and the examination due. The policy in terms only requires 51% and higher within Ashford, doesn't it? That's the spatial strategy.
Well, yeah, if you're looking at it in numbers, in those sort of numbers terms, I guess, yes, but I don't think it's just about a number, is it? It's about actually ensuring that housing's delivered in the most sustainable location and to meet the strategy to fit with where the employment allocations are and all of the other infrastructure that's been provided at Ashford. What
it says, it will be at Ashford in its periphery, comma, as the most sustainable location. The reason why it seeks the majority is because the judgment is reached that that is the most sustainable location within the borough.
Yes.
Yeah, so this point about the most sustainable location, the only reference in the policy to most sustainable location is justifying why the majority of new housing should be at Ashford, isn't it?
Yes, but that's why it should be there.
Yeah, but the idea, but in relation to other sites elsewhere, there is no test of whether it be, such as the appeal site, the most sustainable location, is there?
Not in this, no, not in that sense. But I think the test is, it's consistent with the settlements, accessibility, infrastructure provision, level of services, and suitability of the site and environmental sensitivity. Yeah,
but you see, I'm sorry, you're not seriously telling the inspector. We've agreed in relation to the fourth paragraph. You've agreed in terms, you said no issue with HMU 5.1, which deals with scale. There's no issue that the scale proposed is inconsistent. There's no allegation that SB2 4 paragraph is breached by you, is there, on terms of scale?
Sorry, I think scale is, I think it is breached in that sense. It's providing, it's not just looking at the scale in relation to the settlement there, it's a scale of the development.
Ms. Goodyear, I'm going to accuse, your evidence is completely incredible in this regard. You said earlier you accept HOU 5.1, which says the scale of development proposed is proportionate to the size of the settlement. And are you seriously saying that is complied with, yet SB2, the proposal is not of a scale consistent with the relevant settlement's accessibility and the various other matters? I mean, I'm afraid it's just not a credible contention I'm going to put to you, Miss Goodyear. In the light,
I think they're slightly different things. And I explain it in my proof, and I can't remember exactly which paragraph, I'm afraid.
Well, well, Mr. Howell Williams can take it to you, but the inspector, your serious evidence is you accept the HOU 5, which requires the following criteria: that the proposal is of a scale proportionate to the size of settlement and the level, type and quality of day-to-day service provision currently available, and commensurate with the ability of those services to absorb the level of development in combination with any planned allocations in this local plan and committed developments in liaison with service providers, gets a tick. And yet when we get to SB2.4, you say it's not of a scale consistent with the relevant settlements, accessibility, infrastructure provision, level of services available, suitability of sites and environmental sensitivity. I mean, the argument you're arguing and trying to say there's a distinction is so subtle as to be incredible, I put to you, Miss Goodyear.
I think it is subtle, but I think it's not just about accessibility, it's also about the suitability of sites and environmental sensitivity.
Yeah, but you consistent with the scale, you're saying, so in the context of SB2, because of the environmental sensitivity, and this point, environmental sensitivity, this site has no environmental sensitivity beyond the settlement or beyond.
In terms of its landscape sensitivity and its contribution to the setting of Tenterden is how I see the environmental sensitivity.
So I'm going to put you in view that it would be impossible. Windfall, we've agreed, is an element, a third, one of three elements of how you meet SB2. And on a site, effectively, that's academic in the context of Tenterden. I'm putting to you what you actually say is you cannot effectively find any additional sites, windfall sites in Tenterden, that would comply with the fourth limb of SB2. Because here we have a site that has no identified environmental sensitivity whatsoever, and yet you say inherently it breaches the fourth paragraph, don't you?
I think this site does. I'm not saying that other sites would and other scales of development would.
Okay. And then we see that new land allocations to deliver 1,017 dwellings are proposed in the rural areas, and then windfall housing development will be permitted where it's consistent with the spatial strategy outlined above and is consistent with other policies of this local plan. Now, I'm not going to ask you about, I want to know, when it says it is consistent with the spatial strategy outlined above, what do you rely on? Isn't that the majority of new housing development will be at Ashford and its periphery?
I think it's both points.
So what's the second point?
The point being about the development in the rural area. It's a strategy of two halves, and both scenarios are part of the strategy.
Yeah, but we know development in the rural area is permissible, isn't it? As the strategy allows rural area development, doesn't it? But clearly the
consistent with all of the requirements in that fourth paragraph that we've just been through, yes.
So any development, let's just understand this. Let's see how the council you're the witness representing the council. So any site that potentially breaches the fourth paragraph, for example, it has accessibility. Let's imagine it has no bus service, for example. That alone would be enough for you to make credibly the allegation it's inconsistent with the spatial strategy.
Yes.
All right. We also note, don't we, let's just deal finally with SB2. For the purposes of calculating the 5-year housing land supply, the shortfall in housing delivery between 2017 and 18 should be rectified over a 7-year period. So the purpose of the plan, the aspiration of the plan was to meet the historic shortfall by 2025, wasn't it?
Yes, I see that.
Yeah, great. Now, can we then please go on to HOU 5? We can agree that HOU 5 is in play. I think that's readily accepted by you, that
Yes.
this is a site adjoining or close to the existing built-up confines of Tenterden.
Yes.
We accept from your evidence that there is compliance with the first 4 criteria.
Yes.
We can agree, can we, that compliance with E is dependent on the inspector's judgment in relation to the evidence called relating to those matters that we've heard from.
Yes.
The same must be true of F as well.
Yes.
The same is true for 4 as well, little 4.
Yes, and obviously the inspector's own judgment when he visits the site.
Of course. At little 5, you must, in view of your early answers, accept that little 5 is passed.
Yes.
And little 6, again, that depends on the Forster Goodwin debate. We can then agree below that residential development elsewhere in the countryside is the category applying, which doesn't fall in the first bit of the policy, so it doesn't include this site. And we can also agree that the final sentence, where proposal located within or in the setting of an A and B, it will need to demonstrate that it's justifiable within the context. Again, I think it's agreed that there isn't harm to the setting of the O and B.
There isn't harm, but it is within the setting of the O.
Yes, but
so,
that element of the policy applies, but is passed, isn't it?
Yes.
Okay. Right. Thank you. Now, in the interest of time, I'm not going to ask you about the other limbs that have been dealt with witnesses, i.e. reason of refusal. 2, 3 and 4, we've dealt with those. But as we can agree, principally, will you accept the proposition that where the inspector places them in the balancing act and the weight he places on those harms is dependent on his conclusions on the evidence, and as you always add the right on what he sees in his site visit?
Yes, it's, yeah.
Now, can I just, one point I do just want to take you up with is reason of refusal 8 and the proposed public right of way. And can we just agree, we can agree factually of where we all know where we are on the round table. This is going to a public inquiry in April when it will be promoted by Kent County Council and there is objection from the appellant.
I'm not sure promoted by Kent County Council is necessarily the word. I think they believe a legal right exists.
All right, that's a very fair point, and the inspector will note your use of language. Let's just deal with that then. What is the policy authority that you rely on that in the development plan for why this should be a material consideration when it's not yet got any status in law?
I think Kent County Council believe the legal right exists, so it doesn't have status in law, I agree, as yet, because it's going to the inquiry. But I think it's still a material planning consideration.
That's not the point I put to you. I didn't put, we'll come on to that, but I want to know where you say the inspector should look in the development plan where a proposed right of way that has not yet been made or confirmed should be considered? Where does the development plan take that approach that you rely on? What do you rely on?
I'm sorry, I think I'm misunderstanding the question, because I'm not, are you asking me about, you're not asking me about the outcomes of the inquiry, because that's not.
No, of course I'm not. I'm not. No one knows what's the outcome. I want to know, here we are in February 2022. I want to know what policy you rely on that this is relevant for the purposes of the development plan when a proposed public right of way is being considered. What policy do you say the development plan has that makes your point that a reason of refusal is justified, valid from the development plan?
From the development plan, I think we reference SP1 and TRA5.
Yes, I know what you reference. All right, let's have a look at it. I want to know what you say provides the policy support for this. As we know, SP1.
So it would be point F, to promote access to wider choice of ease of use of formal transports in walking, etc., and promote a healthier lifestyle.
To promote, if anyone walks on AB7, there is no right in law for anyone to have access across the site currently. No one has any right at all in law, do they? You can't to promote access. There's no right there, is there?
At present, there's no right, but well, there's a very clear footpath on the ground.
But that's meaningless in law, frankly. There's no. Let's just see how weak this point is. Where does it stop then? If I put a notice in the paper and say I think I've got a right to walk across a field outside your house, the field you own, I don't know if you own a field, but if I say I've got a right to do that, does little f bite? Because I'm saying that effectively I use the field to pass and repass. It does. No, go on, just let me finish the question. Does SP1F, so to speak, then start to bite and protect that aspiration of mine or that expression of mine?
I think the point is Kent County Council have reviewed the evidence and considered there is a legal right, and that's why they made the order.
I'm not in
and that's
any
my
shape.
Understanding of it, and
yes,
the inquiry is just to confirm it. So
just to confirm it.
So it's not the same as somebody just decides to walk across your piece of land.
I'm not interested in what Kent are doing. I've got no interest in that. I want you are the planning witness for the council. I want you to tell the inspector when little f, if you put the interpretation that you've just sought to do on little f, I want to know when it bites. What's the threshold for activation of f? Because you clearly think that Kent County Council putting forward an unconfirmed order engages little f. The strategic policy of this council, you say, is engaged when someone puts forward a proposed footpath which is not yet confirmed, don't you?
It's not yet confirmed, but they believe a legal right exists.
Yeah, we all understand
and
that.
I think it's something that should be considered. And as I said, it relates to the design and layout of the scheme as well.
Okay, so that policy applies even to a walking route which has no status in law of any kind currently.
I think it's specific to this case.
No, I want an answer to the question.
But that's my answer. It is specific to this case.
I simply don't understand that.
Because Kent believe in this case there is a legal right because they've reviewed the evidence.
Yes, but the whole purpose of the objection process. A county council can think many things about many routes and many rights of way. That's why there's a process of objection to see whether their view is correct or not. The law builds in a review process, which is the objection, doesn't it? Have you known in your practice where rights of way have not been confirmed after an inquiry or not? Do you think they have 100% success rate?
I don't know.
You don't know. But just going back to the question, which I'm concerned with the planning case, just tell, in your judgment, is there a threshold by which F applies or not, or would it apply to any such allegation that F would be engaged?
I don't think it applies to any allegation. I feel that in this case specifically, there's the Kent are happy with the legal right.
Okay. And what other policies are you relying on? Just remind me what other policies.
It was TRA 5.
TRA 5. Thank you. Let's just take that up. Page 260.
Yeah, I'm there.
TRA 5. First bit of TRA 5 deals with development. Development proposals shall demonstrate how safe and accessible pedestrian access and movement routes will be delivered and how they will connect to the wider movement network.
Mm-hmm.
I didn't, that deals with what the development does. AB 70 is about the proposed. Then we see opportunities should be proactively taken to connect with and enhance public rights of way whenever possible, encouraging journeys on foot.
Mm-hmm.
So again, this AB 70 is not a public right of way, is it?
No, not at the moment.
No, so why is TRA 5 engaged?
I think it's trying to ensure that if it becomes confirmed, it's taken account in the development plan, in the proposals.
If confirmed, you said that if confirmed, I mean, it's completely different position post when it's confirmed to now. Why do you say TRA 5 is a policy that is relevant now when it does not, on your ready evidence, engage with a public right of way?
Because I still think it should be taken into account because it's the inquiry is coming up in April. We've got a route. It should be considered. I think Kent were just asking the applicant to consider it and show the route to understand that it can be delivered and meet those tests.
No, but they aren't. Those tests, I'm sorry, Miss Goodyear, those tests are not applicable based on TRA 5, are they? There is nothing in TRA 5. Be fair and objective. TRA 5 in no way bites against a potential public right of way, does it?
It bites when there is a public right of way.
Exactly. So TRA 5 does not apply to a potential. It bites when there is a public right of way.
I've already said that, yes.
Yes. So TRA 5 cannot be used to support reason of refusal 8 in the light of that answer, can it?
Yeah, yeah.
That's yes, it cannot be relied on, isn't it?
It cannot be relied on until it becomes a public right of way.
Thank you. Now, can we then please pick up your rebuttal?
Which section?
It is your table 3, please, page 15.
Yes.
Right, I'm going to ask you about we've got, let the inspector go, we can agree, both you and Mr. Ross give substantial, well, we've got, let's not get into that torturous debate of what's higher, significant or substantial.
Mm-hmm.
For the purposes of my questions, let's assume that significant and substantial are one and the same. Are you happy with that?
Yes.
It's because it's just language. Then affordable, Mr. Ross gives it more than significant, you give it substantial benefit.
Mm-hmm.
Have you read Mr. Taylor's appendices where he dealt with a housing need in Tenterden?
Yes.
What is the current level of those on the housing register who've expressed a desire to live in Tenterden?
I don't know off the top of my head. So
Have you got any idea? Is it 10? Is it 20? Is it 50? 100? 400? Or do you just simply not know?
I can't remember.
Well, could you take up Mr. Taylor's appendices, please? It's CD 7.13B.
13B. Yeah.
Actually, I think it's in Mr. Ross. Sorry, I apologise. I think my reference is wrong. I think it's in Mr. Ross. Just let me check it. I think it's in Mr. Ross's appendices. Yes, I apologise. It's Mr. Ross's appendices, his Appendix 5, which is a briefing note from Lichfield's dated December 2021. And to help you, it's Mr. Ross's appendices, and it starts on page 67 of 103.
I'm looking online and I've got his as 3 different documents.
Okay, well, could you go to his appendices, please?
Oh, yeah, sorry. Yeah. And page 167.
It's page 67.
Yes, I'm there.
Could you go, please, to table 3.2?
Yep.
And you see, this is households on the housing waiting list held by your clients.
Yep.
And this is the 5-year period, the recent 5-year period. And we can see those effectively on those on the register living in Tenterden, those living in other areas, the total within Ashford on the waiting list, and then there's the number wanting to live in Tenterden.
Yes. And
we can agree that the number living in Tenterden has gone down by 18 in 5 years, from 77 to 59.
Oh, right, yeah.
Then we've got the number living, the housing register in Ashford has basically barely changed. It's 34 better from 2016-17 to 2021, isn't it? 1,498 to 1,464.
I'm not great at maths in my head, so I'll
Well, don't worry, you were well enough to correct me on my 6 times bigger than 10 times bigger. You've got more credibility than me as a mathematician so far. But basically the point is that the overall housing number on the list, as we can see, I mean, in 5 years, the improvement is 50. I mean, it's barely moved, hasn't it, in 5 years? 1,575 as opposed to 1,523. That's an improvement of 52, isn't it?
Presumably people are coming on and off the list.
Well, of course, they absolutely are. But it must be the policy aspiration. When we look at the development plan, your client has an aspiration, understandably, to house people, hasn't just run up the white flag. The aspiration, that's why you're seeking 40% affordable housing. You want to house people on the waiting list, don't you?
Yeah.
It's a planning good, isn't it? To reduce, in a perfect world, those on the housing register would be 0, wouldn't it?
In a perfect world.
And we also note that those wanting to live in Tenterden on the housing register has significantly, it's almost doubled from 266 in 16-17. There are now 454 people, households, actually they're households, these figures, who want to live in Tenterden.
Yeah, that's gone up by just under 200.
Yeah. Do you know how many affordable housing units have been provided in Tenterden in the past 5 years?
It's not a figure I have off the top of my head.
So in relation to your substantial, can we agree that in giving that weighting, you couldn't recall the numbers on the housing register wanting to live in Tenterden?
Yeah,
And you're not aware of how many houses have actually been built in Tenterden to meet the need identified?
no,
Do you know how many houses have been built in Ashford in the past 5 years to meet the affordable housing requirement?
no, I don't know that either.
Then we go back. Can we go back to your evidence, please?
Yes.
And where we were on, sorry, your rebuttal.
Yeah.
We also know that in relation to affordable housing, we know, do we not, that the need identified in the 2014 SHMAR was about, I think it's 384 units.
Yeah, I'll take your word on that unless you want to go back to it.
Well, let me just, can I show you, please? I think Mr. Ross has this table. Could you take up Mr. Ross's evidence?
Which page?
Just trying to find my reference. Just let me get it. No, sorry, I'm on the, again, could you go to the statement of common ground? That's where the figures are. Statement of common ground, and it is, the reference is table 6 in the statement of common ground. And I know you're going to ask me for page number, and I will give you that. Yes, it's on page 26, please. So it's 6.32. Tell me, have you got the statement of common ground?
Yeah, 6.32. Yeah.
We note that Ashford's identification in their 2014 SHMAR was a need of 368 affordable housing units per annum to 2030. So, and then we note that Paris 6.2 of the local plan, which sets as lowercase text to HOU1, we can go there if you want, establishes that around 50% of all future houses delivered in the borough should be affordable.
Mm-hmm.
But a lower policy requirement is applied in practice.
Yes.
Now, do you see effectively the affordable housing completions that we have in that table over the 10 years? It effectively equates to 1,326.
Yes.
Now, of course, it's noteworthy that's not the same period as the need, because the SHMAR starts in 2014 and this table is 2011-12. Do you see that?
Mm-hmm.
Now, we also note, do we not, if you go, frankly, to what we can effectively agree, can't we? If the plan since 2019 is seeking 50%, and we can see the figures, 2020, 2021, we see 153 affordable housing units.
Plan, we're seeking 40%.
Yeah, all right. Plan.
Sorry, you said 50%.
Yes, because no, the SHMAR, sorry.
Okay.
The SHMAR, yeah, the SHMAR 50%. Table 6, you've got a figure of 153, 2020, 21.
Yeah.
Now, from memory, and you'll tell me because you were the HLS, how many houses were completed in Ashford last year?
Last year, it was over 1,000.
Over 1,000. So as of last year, can we agree broadly the affordable housing contribution as of the overall figure is running at about 15%? If you have 153 of 1,000, there's about 15%, correct?
Yes, that's what this table seems to show.
Yeah. So what we have, and frankly, we could go back and do the laborious exercise of going through the previous years again, but I'm going to put to you that this table 6 shows that what Ashford are doing is basically its affordable housing contribution in the period of the SHMAR is roughly, applying the maths, is between 8% and 24% of all housing completions. If we say that on average, housing completions is 1,000 a year over the past 6 years.
Yeah, kind of trusting you on the maths.
Yeah, no, sure. Trust me on the maths. Actually, I'm being unfair to myself. I don't want to sound like Mr. Smith and Mr. Goodwin, but actually there have been some years, I think, where the council have exceeded 1,000 houses, so the percentage would be lesser over the past 5 years. What's the record year in the past 5 years of completions? Can you recall from yesterday?
I can't recall.
No, well, I'm not surprised, and I don't blame you. But basically, that's the reality of affordable housing, isn't it? Let's just summarize it. So you've got a need identified in the SHMA for 368. The SHMA seeks 50%. The development plan seeks on those qualifying developments of 40% in policy terms, doesn't it?
Is 40% in the development plan? Not sure when you, sorry, I was just confused. I'm just not sure about the word seeks in the SHMA. It's established.
Okay, established. All right, let's forget seeks, establishes. Well, I think that's frankly a really poor point, because if you go on, it says should be affordable. Should or seeks are pretty similar, aren't they? The aspiration is that 50% of all future houses should be affordable.
Yeah, it's an aspiration, but it's not a policy tool though, is it? Sorry, that's what I was trying to just.
Okay.
The policy is HOU1.
But the inspector can note when we've agreed the result of when we got the affordable housing completions, the fact is on every year of the plan period, the affordable housing completions are significantly below the policy aspiration, isn't it? I mean, we've looked at that. Last year, 153, approximately 15. The year before 8%, the year before 14%, the year before 10%. These are all predicated on 1,000 units a year total. If you say I'm seriously wrong in that, I'm quite.
It's below.
Below.
Below the 40%.
Yeah, but we can note, can't we, that the reality is in affordable housing, the plan is completely failing for whatever reason to provide its policy target for affordable housing. It's lamentable, actually, the performance. I'm going to use a strong word because it is. These are people in need, the poorest, most vulnerable people, often without housing, and the council is delivering 15% affordable housing. That is lamentable, isn't it?
That's what the council's delivering.
Yes, but I'm going to ask your judgment. Is it unfair of me to call a 15% affordable housing contribution lamentable when one looks at what the policy aspiration is?
I have to say, I've never come across the word lamentable before, so I don't know.
Okay, well, there's always a first. All right, if you don't know what lamentable means, would you accept it's a poor performance during the plan period for the delivery of affordable housing?
I would accept that's a poor performance.
And putting all of that together, then, frankly, I'm going to put to you that you're going back to your rebuttal that Mr. Ross is completely right when he gives it more than significant benefit, the provision of affordable housing in the light of what the need is, the number on the housing register, what has been provided, i.e. the shortfall that exists for affordable housing. It's completely right that it should have more than significant benefit, isn't it?
I don't agree with Mr. Ross. I still agree that it's a substantial benefit.
But
delivery of affordable housing is a substantial benefit, and that's the weighting that I give it.
Yes, but what factors do you apply that stop you from going up to more than significant? In the light of the journey we've just undertaken, what factors do you rely on?
I just think it's as a benefit, it is substantial. That's the factor I'm giving it. It's a delivery of affordable housing. it is a benefit. So yes, I reckon it's the delivery of those affordable units. I think it's 70 something units, 72 units.
72 units, which would amount to 50% of the level of affordable housing completions in the whole of Ashford last year, wouldn't it?
Yes, I think
15,
yeah,
whatever it was.
Yeah.
Roughly.
But
I'm afraid you know what, in answer to my question, you didn't identify any factor. I mean, I'm going to put to you that you have no factor which stops you joining Mr. Ross on the more than significant step. You have no factor that you've identified.
I think I have identified it's 72 units. It's not.
No.
It's not going to deliver. You know, it's only a proportion. It's still, the scheme would only deliver a proportion of the need out there. I think that's the fair weighting to give it.
But that, I'm sorry, you're now really getting into interesting territory. So basically, you make, on applying your weight to affordable housing, you make a judgment on to what extent the overall need is met by one proposal. Is that right?
I'm making a judgment on the amount that's being delivered in this case.
Yeah, I know you are.
To how much the benefit, to assess the benefit, it's how much is it this scheme delivering.
So Mr. White, I think you're getting into a bit of a.
I don't want to say I'm moving on. I'm moving on.
I don't think you're going to make any difference the way you're going at the moment as to what I've got the notes of both Mr. Ross and Miss Goodyear's ideas of what's, I mean, substantial or more than significant. I mean, I'm not even sure what the difference is.
Well, you'll hear from Mr. Ross. I mean, sir.
Yes, I can hear from Mr. Ross.
You'll hear from Mr. Ross.
I mean, considering they're not the same, because Mr. Ross has used significant and Miss Goodyear's used substantial, and you're suggesting they're the same, significant, substantial. So I think we can't explore this much more on that.
No, don't worry, I'm moving on.
Yeah.
Right,
Yeah,
next,
thank you.
Next point, open space. Again, I mean, I think, frankly, your conclusion of moderate, well, I'm going to use a strong word, borders on the outrageous when you look at the policy aspirations of your council. My client is producing 12 hectares of open space, which is currently not lawfully open to the public. 12 hectares on 141, 145 development, whatever, up to 145. 12 hectares of open space, country park, the country park, and you can only give that moderate. Why?
Yes, I give that moderate.
Why?
Because I've given it a benefit, but I don't think it's a significant benefit. I don't think it's the same level of benefit as the housing and the affordable housing. That's the weight I've given it, attributed it. I don't think, I just don't think it gains any more benefit than that. And I think I've explained in my proof. Again, I might have to be taken back to the reference, and I've explained that weighting in my proof.
And we note, did you reach that weighting in the light of the third priority of the council to improve recreational opportunities within the borough? Were you cognizant of that was the third corporate priority?
Yes, taking everything into account. That's where I've gone to with my weight.
And then the sports pitches, again, limited benefit to the provision of 5 new pitches in Tenterden, and you can only give that limited benefit, again, in the light of the policy aspiration for improved recreational uses in our towns.
I think, as explained at the session on the sports pitches, I think the council still doesn't understand, that hasn't got confidence that this isn't going to be a white elephant.
But that doesn't go to the benefit. Right, let's just cut this call. I don't want to retread what we dealt with. On the assumption that the inspector concludes that they will be provided come forward in the ambit of the 106 and the conditions, and I know there's a whole debate, but on the assumption that they will be delivered and used, what weight would you give to that in that position?
It will be delivered and a user's found, and they will be maintained for indefinitely.
Yes. Like
I think at the moment we don't have any confidence in that position. I would increase it to moderate.
I'm not, in the interests of time, I'm not going to deal with avoidance of other benefits. I'm going to, but you can accept, actually I will, because I am. In a heavily constrained location, the point Mr. Ross is making, it must be a benefit to provide an identified need on land that is the least harmful, must it not? That's not A and B, not in national park, not on other constrained sites.
I just don't see that as a benefit. It's not, this site is, which site will this site stop coming forward?
A site.
It's not this site or another site.
Of course,
We're not being asked to consider here that if this site comes forward, another site is going to remain in perpetuity as rural green space. That's not. So I just don't see that as a benefit.
Well, it shows you're misunderstanding the position. You accept that the need needs to be met. If it's not met on this site, it's still be incumbent upon the council to find the shortfall, won't it? Somewhere else.
Yeah, and they're not going to find it in the A and B.
Well,
necessarily, are they? It's not
no,
the case that because, and I don't think you can make that assessment or judgment or be asked to, because you're not saying that 145 dwellings won't be built here, here, and here. So I don't see how that can be a benefit.
Okay, all right.
It's just a function,
Well, we know, don't we, that the council in Appendix 3, when one looks at SB2, and I dealt with this many moons ago with Mr. Withercombe, that the majority of Appendix 3, the council's allocations, are greenfield sites, aren't they?
Yes.
And also, do you know, in 2019, are there? Yeah, no, that's fine. Okay. Next thing, I'm going to leave the benefits. We obviously don't want to get into those benefits that are obviously dependent on the inspector's conclusions and the evidence, so to speak. I just want to deal with, again, I've got a problem with your economic limited benefit. I mean, as you've agreed, you've reached that judgment. You have no idea what the proposal will bring forward in terms of economic benefits. How many jobs will actually be sustained during construction?
I don't know, but I brought that forward on the position the construction jobs will be a temporary period. And so I've considered that. And also on the economic benefits to Tenterden, and considered the local plan inspector's comments, where he said that Tenterden was thriving and didn't need additional housing to support it effectively. And I've also based that on my own experience of the town centre.
But so the way you weigh economic benefits is subjective to where those benefits would be. If we were in an area of great deprivation, it's your view, let's say a place which falls within the top 20 most deprived areas of England, that would affect the weighting as opposed to the location of a town which is thriving. That's your judgment that you make. You effectively apply the subjective circumstances on weighting.
It's a judgment.
Okay, fine. I'm going to put it to you that I frankly haven't seen that approach taken by the Secretary of State or an inspector. Have you? Have you seen one where that he takes into account where the economic benefits will actually be received, so to speak, and the weighting placed on it?
The inspector in the local plan took it into account.
That's not. No, that's.
I can't take you to anything right now.
The inspector in the local plan, completely different. I'm amazed you're trying to rely on that as context. The inspector was considering the spatial strategy for Tenterden over the plan period, wasn't he?
Yes.
That's completely different exercise to an inspector in a Section 78 attributing weight to benefits in a planning balance, isn't it?
It is a different exercise.
And then we've got the other elements. Just tell me this. I do just want to trouble you on why do you only give moderate harm to the public right of way in the balance? Is that because of an acceptance of where it sits in the process?
Yes.
Thank you. Now, overall, what I do want to ask you, because you haven't dealt with this, let's go down, please. The benefits, what you don't tell the inspector, and I'd like to know, overall, on your table, we've got substantial, moderate, because you changed sports pitches to moderate, to
if the inspector decides
Yes, that's
in
fair.
a hypothetical
That's a fair point.
situation.
On the hypothetical, yes. But even then, highways, transport and access, very limited benefit. But overall, I just want to ask you, on your planning balance, what cumulatively do you give the weight to the benefits in the tilted balance?
Cumulatively, in the tilted balance, I still see that the harm significantly outweighs the benefit.
No, that's not, Miss Goodyear. That's not I'm not interested in the harm. Forget the harm. I'm asking you about the benefits, the weighting to the benefits. That's all I asked you. Forget the harm. What weight overall cumulatively? So your substantial, moderate, limited.
Yeah, I think
Very
and taking
limited,
all
limited.
It's a balancing. I don't have a word to describe it to you because I'm balancing all of those different weights against the harm, the weights to the harm. So I'm not sure how I can describe this because
Of course you can.
It's a picture in my head.
You've got 7 benefits. You accept the development will bring forward 7 benefits, and you give 2 of them substantial weight, 1 of them moderate, 1 of them limited, 1 very limited, 1 limited, 1 limited. Cumulatively in the planning balance, what weight do you give to those benefits?
So that's how it is: 2 substantial and 5 substantial harm. That's how the benefits are weighed in my head.
No, but that's not. So, well, that's a completely inappropriate exercise because you dismiss anything that's not.
I'm not dismissing anything else. I'm just trying to.
Let me finish the question.
I wasn't trying to dismiss. I'm trying to explain. I wasn't trying to dismiss everything else. I was just trying to explain how I'm weighing it.
So, yeah. So but you have 7 benefits on your, and you have 6 hot. Well, no, you've got 7 benefits, and then you've got, even on your evidence, you've got 7 impacts with different weighting, 7 benefits. But I still go back to the point, and I'm going to give you a chance. If you don't answer this, I'm going to put in closing that your planning balance under para 11 is not credible if you can't put a cumulative weighting to the benefits in view of the tilted balance under paragraph 11. And Mr. Howell Williams, stop shaking. It's so rude to just. So I do object to Mr. Howell Williams showing his frustration. Yes, I am talking about you because every time I put a question,
please, I don't know what Mr. Howell Williams is doing, but
shaking his head constantly.
He's on mute at the moment. But
I'm not shaking my head constantly. I was looking to my learned junior, and we were swapping thoughts.
Yeah, so I think that's unfair on Mr. Howell Williams because I don't know what he's doing. So
well, maybe I should take your approach.
He'll have a chance to re-examine anyway, and he'll have a chance to ask questions of Mr. Ross as well. So hopefully that's not distracting you too much. But really, this is just to help me, not to,
absolutely.
I didn't even know what Mr. Howell Williams was doing. So
okay, great. Well, maybe I should take your approach and I should exclude Mr. Howell Williams from being visible. Miss Goodyear, going back to can I just ask you last time? I've asked you 3 times. The inspector, we've agreed, needs to apply a tilted balance. They're on that one side of the balance is the benefits. We can agree on the other side of the impacts.
Mm-hmm.
The inspector needs to weigh all the benefits that you say this proposal will have.
Yes. Against the harm.
Yes, of course.
Yeah.
But I'm only looking at the benefits at the moment. When he looks at your evidence, what do you say is the weighting he should give cumulatively to your benefits?
I don't give a cumulative. I split them out into individual benefits as I do the harm.
And it's your view that in doing that, in not adding up the benefits together, you can still do a paragraph. Let me finish your question. No, I won't finish the question. Give me your answer. You think the question is.
No, go ahead. Sorry, you want to ask the question.
Thank you. In relation to paragraph 11, you think that is an appropriate way to go about paragraph 11? That's your judgment, is it?
No, I've added the benefits. I haven't gone, there's one benefit. It's not one benefit versus one harm. I've weighed the benefits versus the harm.
Exactly. We're on the same page. But in doing that, I want to know if you add all the benefits and add all the impacts. I want to know what in that.
And I come to the conclusion, as I've said, that the harm outweighs the benefits significantly and demonstrably outweighs the benefits. There's 7 harms, and they all have substantial, and that's the conclusion I've drawn.
I understand.
Don't know what else you want me to say.
I'm not asking you about that. I know what your conclusion is. But in order to give credibility or not to that judgment, I want to know, which is fair, when you were writing this rebuttal and adding them all up, what weight did you give to all the benefits that you say must be taken into account?
Gave the weight that I set out in the table.
Which is what? To each individual items, is that how you do it? You add up each individual
item, then consider each individual item as a group. And I've considered them all as a group, and I've come to that. And then I came to the conclusion that the harm, the benefit, I'm getting confused now too, that the harm significantly, sorry, I just lost it. The adverse impacts of the development significantly and demonstrably outweigh the benefits.
Okay. Can I just ask, since you wrote your rebuttal in the passage of the past, are you okay? Do you want to break for 2 minutes?
No, I'm okay.
When you've said the break, I mean, I'm aware that you've gone over an hour.
Yeah, no, I'm about to stop.
Okay, thank you. Thanks.
Can I just ask, in the light of the past 7 days of evidence at this inquiry, have your benefits or impacts changed in any way in the light of the evidence? Because in your impacts, as we've agreed, and there's absolutely no criticism, you're dependent on the witnesses who support each reasonable refusal. I just want to ask,
they haven't changed.
Your impacts haven't changed, and have your benefits changed?
Benefits haven't changed.
Thank you very much. Thank you very much, Ms. Goodyear.
Thank you.
Thank you, sir. That's my cross-examination.
Right. Thank you, Mr. White. What I'd like to do next is, Mr. Howell Williams, have you got much re-examination? Have you got an idea of what time you'll take over re-examination?
So actually, I won't be very long. I'm happy to carry on now, subject to what Ms. Goodyear says. I'm estimating 10 minutes, maybe less.
10 minutes, right. So in that case, there's not much point in having an adjournment then. So what I'll do then, I'll have the I mean, I've not got any questions of my own, but if you can do your re-examination then, and then we'll adjourn for today, and tomorrow will be Mr. Ross, I think. So that's, but also there might be a chance for Mr. Poole either to provide a written brief statement or even read it out if he wants to. But so I'll hand over to you, Mr. Howell Williams.
Thank you, Ms. Goodyear. There were 5 matters I wanted to ask you about, and taking them in the order that they arose. If you remember, right at the beginning, you were asked about officer assistance from the council. Do you remember?
Yes. You might have to fill me in more detail.
Well, you were asked, and you said, well, you know, the limited capacity.
Oh, yes, yeah.
The inspector has already heard in slightly different contexts about the pressure on resources and staff at the council. But do you feel in giving the evidence you've given to the inspector that you've been hampered in any way in presenting sufficient evidence for him to make a proper judgment?
No.
And you were asked in a sort of roundabout way whether you were familiar with this area, and you said, I think, you lived in Hampshire. Do you feel, slightly strange way of putting the question, do you feel in any way disadvantaged by living in Hampshire as opposed to Ashford? Or put it another way, do you feel that you're lacking any experience or knowledge in order to present to the inspector sufficiently your professional judgment to help him?
No, I live in Dorset, but no, I don't.
Dorset.
Yeah,
Right,
just-
I don't know why Hampshire came to my mind.
no odds.
The second matter is this, perhaps more helpful, hopefully, to the inspector. Do you remember you were asked about your approach to the section 38.6 question?
Yes.
Yeah, that proposals should be determined in accordance with
With the development plan,
plan
yes.
unless material considerations indicate
otherwise.
that's the fall. And Mr. White put it to you that in doing that, exercising that judgment and striking that balance, as it were, you were untroubled by the shortfall in housing. And you said,
Yeah, he did put that to me.
yeah, you disagreed with that.
Hmm.
And you indicated on more than one occasion that you applied full weight to the policies, in particular at that stage, I think SP2.
Hmm.
Right?
Yes.
Is the shortfall of housing, you've made the point perfectly clear in your written evidence, is that a material consideration?
Yes.
It is. And have you taken that into account?
Yes.
And have you taken that into account in striking the section 38.6 balance and answering the question the statute poses?
Yes, because it's a material consideration.
Thank you. And then you were asked somewhere later about policy SP2.
Hmm.
Just have that to hand, page 22.
Yeah. Yes, got it.
And do you remember you referred to the target figure of 13,118?
Yes.
And it was put to you that that figure had been superseded. And you said, well, in terms, I didn't get a full answer, but in terms of the housing, the 5-year housing land supply, which is referred to below,
Hmm.
further down to that. And plainly, it appears that that's perhaps part of what the appellant is saying is this is out of date in some way.
Mr. Howell-Williams, you're wrong. She accepted that proposition. She accepted that proposition that it was out of date. It's not appropriate for you to ask questions on it.
It is quite appropriate for me.
No, it's not.
Said,
Sorry, can I just hear what the question is? I don't know what the question is yet, Mr.
yes,
White.
it was put in terms of superseding, and you said, and I have a clear note, supersedes in terms of the housing land shortfall, right?
Yes.
That's what you said, and I want to ask you questions about what you said to help the inspector. The figure of 13,118 does that refer to the 5 years or a different period?
That's the plan period, so it's a different period.
Is
13,118.
sorry?
Yeah.
Yeah, thank you. So far as the 5-year housing land supply is concerned, is the requirement figure that is agreed derived from, drawn from policy SP2?
It is in part.
So is it taken into account in the 5-year housing land supply calculations requirements?
Yes. Yeah.
Okay, thank you. And with that in mind, is it your advice, Inspector, that the figure is out of date, up to date, or would you use some other description?
I think it's up to date. It's the figure for the plan period.
Thank you. Fourth and fifth points are merely references for the inspector. Do you remember you were asked questions about a particular part of SP2 about the settlement, and you made a reference, I think, to HOU criterion little a, remember?
Yes.
You said, well, there is a difference between them and you've referred to it in your proof.
Yes.
The general matter is covered in sections 5 and 6, but I think you had in mind, in particular, paragraph 513. You don't need
Yes.
to type it. I'm going to ask the inspector to make a note. And a further reference that you were looking to was in relation to open space. Do you
Yes.
remember?
Yeah.
And your attribution of moderate, and the reference there to the inspector, 7.3.
Yes.
So those are the questions I had for Ms. Goodyear in re-examination. Thank you.
Right. Yeah, thank you, Mr. Howell Williams. So that really completes the evidence of Ms. Goodyear. So really tomorrow, like I say, we'll be hearing Mr. Ross. Thank you, Ms. Goodyear. So in terms of the timing for tomorrow, I'll be resuming at 9:30. Mr. Ross, evidence in chief, Mr. White, what sort of?
About an hour.
An hour. And Mr. Howell Williams, have you, I mean, I know it's a bit difficult in terms of cross-examination, but have you got anything, any idea?
I think probably best to say 1 to 2 hours.
1 to 2 hours, and then there'll be so that's say on the worst scenario 2 hours, so that's 3 hours. So I would have thought we might hear Mr. Ross tomorrow completely. Any concerns about that? No. I'm sure Mr. Ross will be happy to have been heard, but I don't know.
So I think we'd all like to finish Mr. Ross's evidence tomorrow, I'm sure.
Yes.
But we've, I think both Mr. White and I've been not entirely accurate on making estimates.
No, I realise that.
My estimate is certainly built upon Mr. Ross not adding or providing, as it were, new evidence. But maybe we can just review it when he completes his evidence in chief.
Yes. Yes, I'm sure that could be helpful. So, and then Mr. Poole, I'm hoping that Mr. Poole, he just said it would be just a short statement of clarifying or just summarising what has come out on his concerns over the inquiry. So I'm hoping that will be coming out tomorrow morning. So I'd like to have that first. So so is Mr. Poole here? Is he present at the moment? Yes, Mr. Poole, are you, now you've heard that evidence that's been given, are you in a position to either provide a written statement or tomorrow morning, or even read it out tomorrow morning?
What I thought I'd do, because I obviously wanted to see the session today, is that I'll work on that now.
Yeah.
And I'll send a sort of written statement, which will be fairly short, and I'll send it to Caroline Williams for your.
Yeah, that'd be
Well,
fine.
you'll have it in the morning anyway, first thing. So
yeah. So I think a written statement is probably sufficient, really, rather than you reading it out, especially if you're just going to read it what you've stated anyway.
Okay.
So if you can put in a written statement, and then Mr. White and Mr. Howell Williams will have, and myself obviously, will be able to have a look at it before Mr. Ross gives his evidence, if that's all right. Is that okay for you?
Absolutely brilliant. Thank you very much.
Right. Thank you. Anything else that anyone would like to raise before I adjourn until tomorrow at 9:30?